This is David for 10 on Tactics, brought to you by Tactics and Trials.com. Please remember to subscribe to the channel and to leave any comments or questions at the bottom of the page. Today, we will review one of the most important U.S. Supreme Court decisions regarding the application of deadly force by a police officer. Back in 2014, the U.S. Supreme Court issued its ruling in Plumhoff v. Rickard, 572 U.S. 765. Plumhoff is an important case for law enforcement because the Supreme Court ruled that officers can use deadly force to end a high-speed pursuit if the driver poses a significant threat to public safety. On May 27, 2014, the Supreme Court reversed the lower court's decision and held that the officers did not violate the Fourth Amendment when they shot the suspect who was operating the car during the pursuit. In a unanimous 9-0 decision, authored by Justice Samuel Alito, the court held that the suspect's actions posed a grave public safety risk and that the officers acted reasonably in using deadly force to end that risk. The court also found that the number of shots fired was also reasonable, writing that if police officers are justified in firing at a suspect in order to end a severe threat to public safety, the officers need not stop shooting until the threat has ended. Finally, the court found that even if the officers' conduct did violate the Fourth Amendment, they would still be entitled to summary judgment based on qualified immunity because their actions did not violate clearly established law at the time of the incident. Statement of facts. In the early morning hours of July 18, 2004, Donald Rickard was stopped by a West Memphis, Arkansas police officer for a broken headlight and a large shattered windshield on the right side of the window. Rickard refused to produce identification or exit his vehicle when asked to do so, and then fled, initiating a high-speed chase across state lines going from Arkansas to Tennessee. During the pursuit, Rickard reached speeds in excess of 100 miles per hour and passed more than 24 vehicles. The vehicle eventually spun out into a parking lot and collided with a police cruiser, at which point Rickard reversed his vehicle in an attempt to escape again. Sergeant Vance Plumhoff fired 3 shots into Rickard's car while it was stuck and as Rickard was spinning the wheels on his car. As Rickard managed to drive away, he nearly ran over another officer. Upon seeing this, 2 other officers fired an additional 12 shots at Rickard's car. A total of 15 shots were fired by all of the officers doing the incident. Soon thereafter, Rickard lost control of the car and crashed into a building. He died from a combination of gunshot wounds and crash-related injuries. The passenger, Rickard's girlfriend, also died at the scene. Rickard's minor daughter filed a Section 1983 federal lawsuit against the officers, alleging excessive force under the Fourth and 14th Amendments. Both the District Court and the Court of Appeals denied the officers' motion for summary judgment based on qualified immunity, finding that their conduct violated the Fourth Amendment and was contrary to clearly established law at the time. The Supreme Court granted certiorari to determine 1. Whether the Sixth Circuit wrongly denied qualified immunity by relying on subsequent case law rather than law clearly established at the time, and 2. Whether as a matter of law the use of deadly force was unreasonable. The Supreme Court held that the Fourth Amendment did not prohibit the officers from using deadly force under these circumstances. Further, the court held that even if a Fourth Amendment violation had occurred, the officers would be entitled to qualified immunity because this right was not clearly established at the time of the shooting. The court began by applying the standard for excessive force claims under the Fourth Amendment. The inquiry requires analyzing the totality of the circumstances from the perspective of a reasonable officer on the scene, rather than with the 20/20 vision of hindsight, citing Graham v. Connor. Then the court turned to whether the officer's use of deadly force to terminate the high-speed chase violated the Fourth Amendment. The key reasoning of the court. 1. The grave public safety risk posed by the fleeing suspect. The court emphasized that respondents Donald Rickard's conduct was outrageously reckless and posed a grave public safety risk. Rickard's outrageously reckless driving posed a grave public safety risk. Specifically, the chase lasted over 5 minutes, exceeding speeds of 100 miles per hour, and the driver passed more than 24 vehicles, forcing several to alter course to avoid collision. 2. The resumption of flight after a momentary halt. A central factual finding of the court was that even though the car spun out and came to a near stop, the court held that Rickard refused to terminate his reckless and dangerous escape. Less than 3 seconds later after being stopped, Rickard resumed maneuvering his car. The court noted that just before the officers fired, when the front bumper of his car was flush with that of one of the police cruisers, Rickard was obviously pushing down on the accelerator because the car's wheels were spinning, and then Rickard threw the car into reverse in an attempt to escape. Accordingly, under the circumstances at the moment when the shots were fired, all that a reasonable police officer could have concluded was that Rickard was intent on resuming his flight, and that if he was allowed to do so, he would once again pose a deadly threat for others on the road. 3. The court found that the use of deadly force was justifiable to terminate the threat by relying on the precedent of Scott v. Harris, 550 U.S. 372, 2007, which dealt with a ramming maneuver in a high-speed chase. The court held, a police officer's attempt to terminate a dangerous high-speed car chase that threatens the lives of innocent bystanders does not violate the Fourth Amendment, even when it places the fleeing motorist at risk of serious injury or death. The court then found no basis for a different conclusion here, given the facts. In light of the circumstances we have discussed, it is beyond serious dispute that Rickard's flight posed a grave public safety risk, and here, as in Scott, the police acted reasonably in using deadly force to end that risk. 4. The court found that the number of shots fired, 15, was not unreasonable. The plaintiff argued that even if deadly force was allowable, the number of shots, 15 total, 3 initially, then 12 more, was excessive as a matter of law. The court rejected this as well. It stands to reason that, if police officers are justified in firing at a suspect in order to end a severe threat to public safety, the officers need not stop shooting until the threat has ended. The court emphasized that during the approximately 10-second span when all the shots were fired, the driver never abandoned his flight attempt and in fact managed to drive away eventually. The court then addressed whether the law was clearly established, such that the officers lacked qualified immunity, stating, an official sued under Section 1999-1983 is entitled to qualified immunity unless it is shown that the official violated a statutory or constitutional right that was clearly established at the time of the challenged conduct. Moreover, the court held that the plaintiff failed to show a controlling case or robust consensus that would clearly establish the unconstitutionality of using lethal force to terminate a high-speed car chase. Respondent must meaningfully distinguish Brosseau v. Haugen, or point to any controlling authority or robust consensus of cases of persuasive authority that emerge between the events there and those here that would alter the qualified immunity analysis. Respondent has made neither, showing the court compared the facts to Brosseau, 543 U.S. 194, 2004, which involved a foot pursuit and the officer firing one shot at the suspect, and found the facts here were more favorable to officers. It then concluded, it was certainly not clearly established at the time of the shooting in this case that the number of shots fired, under the circumstances present here, rendered the use of force excessive. A critic may argue that the court's toleration of 15 shots raises concerns about proportionality of the force applied and whether the use of force was excessive even if justified in principle. Another point to consider is if the force was necessary. Because the decision emphasizes the split-second judgments and rapid evolving circumstances, it may limit challenges to use of force in similar vehicular flight contexts, potentially broadening lethal force justification. This decision underscores the delicate balance between the protection of public safety and constitutional limits on police use of force. But in light of the passage of time since this decision, one should take heed of the other elements that are prevalent in any use of force analysis in today's force encounter. Many courts are factoring in the issue of necessary force and proportional force when reviewing any force incident, aside from all of the Graham v. Connor factors. The decision has several significant implications for policing practices. Some of the major ones are: 1. Affirmation of high threshold justification for deadly force in vehicle flight contexts. The court reaffirmed that the Fourth Amendment does not automatically forbid deadly force in the context of a dangerous high-speed vehicular chase, even when the driver is unarmed, provided that circumstances show a grave risk to public safety and a continuing flight. Thus, the case strengthens the notion that vehicular flight can itself constitute a deadly weapon scenario. One can conclude that the court is recognizing that an individual driving a vehicle that weighs thousands of pounds and operates it in a way that could kill or seriously injure a person is in itself deadly force. 2. Emphasis on the objective reasonableness standard under Graham and Scott decisions. The court continues to apply the objective reasonableness standard from Graham v. Connor, 490 U.S. 386, 1989 in use of force cases, and stresses that courts must assess what a reasonable officer on the scene could have concluded, rather than engaging in hindsight second-guessing. By invoking Scott, the court signals that analogous chase termination force might receive similar treatment. 3. Effect on number of shots fired and continuing threat factors. The court's statement that officers need not stop shooting until the threat has ended is a strong endorsement of the idea that once the use of deadly force is justified, subsequent rounds in quick succession may still be constitutionally permissible so long as the threat remains ongoing. This has downstream implications for how courts evaluate the excessive force prong in multi-shot cases. But again, all of this needs to be tempered with recent case law regarding necessary force and proportional force response. A close read of McBride v. Gonzalez will provide insight of the Ninth Circuit's perspective on a similar dynamic. 4. Limited guidance on the boundaries of excessive force. While Plumhoff clarifies one scenario, high-speed chase culminating in threat to bystanders, it does not define the full boundary of when deadly force is excessive in vehicle contexts. It leaves open many fact-specific questions, e.g. slower speed chases, minor traffic infractions, no continuing flight, no risk to bystanders. In that sense, the case arguably narrows plaintiff claims by anchoring reasonableness to a strong factual scenario. 5. Practical implications for law enforcement. From a policing viewpoint, Plumhoff may encourage departments to treat fleeing motorists in high-speed pursuits as high-risk threats and justify use of force to terminate them. It also signals that agencies and officers may have more robust legal protection when engaging in aggressive chase termination tactics or firearm interventions than had been assumed in some federal circuits after the Scott decision. However, it also requires that the factual record show the flight risk, the danger to bystanders, and that the suspect continued to flee, and almost striking an officer in the process after shots had been fired. In addition, one must pay attention to recent court decisions regarding application of deadly force in rapidly evolving situations when alternative means of ending the encounter are feasible. Some issues to consider with this case. The court was unanimous, though parts of the opinion had different joiners. The strong consensus gives the decision significant weight. However, the decision does not create a blanket rule that any fleeing vehicle may be shot at. The factual risk to bystanders, continuing flight, high speed, and the possibility of colliding with other vehicles all matter. Courts will still need to do an objective reasonableness inquiry on a case-by-case basis. The need not stop shooting until the threat is ended. Language is powerful, but the court also defined the time frame. Here, the shots were fired during a 10-second span when the driver had not given up his flight. It explicitly distinguished hypothetical subsequent rounds fired after flight had ceased. From a policy perspective, the decision carries significant implications for the intersection of public safety and individual rights. Some critics view it as expanding law enforcement's ability to use deadly force. Proponents view it as enabling officers to protect innocent bystanders from dangerous vehicle flights. However, in light of recent Federal Circuit decisions, particularly in the Ninth Circuit, one will need to also factor in more than just Graham factors in their argument.